On January 7, 2026, Christine Frances Lazinski was charged with operating while intoxicated pursuant to Michigan-compiled laws following a traffic stop initiated by Corporal Dane Hunter of the Flat Rock Police Department. The encounter began during a general road patrol near northbound Telegraph Road and Gibraltar Road. District Attorney Roger Kyan contended that Corporal Hunter observed Ms. Lazinski's pickup truck cross the double yellow lines multiple times after turning onto Gibraltar Road, constituting a series of lane violations under the Michigan Vehicle Code. Before trial, defense attorney Edward James Holmberg filed a motion to suppress, arguing that the traffic stop was an unlawful investigatory seizure from its very inception under both the Fourth Amendment to the United States Constitution and Article 111 of the Michigan Constitution of 1963. Defense counsel asserted that Corporal Hunter lacked the reasonable, articulable suspicion legally required to justify a warrantless vehicular detention and relied heavily on the officer's own Bodycam footage to challenge his written report. On April 30, 2026, a pre-trial hearing was held before Judge Michael K. McNally. After the state and defense waived their rights to an opening statement, Mr. Kyan called its first witness, Corporal Hunter, to the stand. Mr. Holmberg wasn't present in the hearing, so his colleague, Ms. Leslie K. Acock, cross-examined Corporal Hunter.
Officer, as a result of this stop, you prepared a written report. Is that correct?
Yes.
And did you complete that report same day or within hours of the stop? I know we're talking the stop was around 10 p.m., correct?
Sounds about right, yeah.
So it would have been, you would have prepared that report that night into perhaps the early morning hours of the next day?
I'd have to see the exact date that I put on the report. It has a date time on it, but that normally is how it goes, yes.
And when you prepare a report, would you intend that report to be accurate and complete?
Yes.
And that report would reflect everything that led up to, we're talking about this particular traffic stop, so your report would have included everything that led up to that traffic stop, correct?
Most cases, yes.
Do you recall, have you reviewed this report in preparation for today?
Yes.
So you're familiar with it? Correct.
Yes.
Do you recall what you stated in the report?
I mean, there's a whole police report, so we got to be a little bit more specific.
Okay.
And then I'd like to review the report if you're gonna ask a specific question about it. Yes.
May I present the report?
Sure.
Refresh the record?
Absolutely.
Just gonna ask that you review it and then when you're done, let me know.
Okay.
In particular, Officer Culture, I'm really was interested in the very first paragraph on the
Okay.
narrative on the second page.
Okay. I got it.
It starts with on 1/7/26 and
Correct.
ends with May 3rd.
Okay. Then your question.
You can, okay, just do me a favor, don't testify directly reading from it. Fair enough?
Okay.
Okay, so according to your report, your observations of Ms. Lazinski began on northbound Telegraph, correct?
Correct.
And according to your report, your scout car was directly behind her car while traveling northbound Telegraph, correct?
Correct.
And you continued to be behind her according to your report as she made the turn onto Gibraltar Road, correct?
Is that a yes?
Yes.
And again, according to your report, you observed her swerving on Telegraph, correct?
Would have been at least one time.
And according to your report, as she turned onto Gibraltar Road, your report says that she crossed over the solid double yellow lines two times or more, correct?
Correct.
And according to your report, you stopped her, effectuated your traffic stop after seeing these two crosses over the yellow line, according to your report, correct?
Correct.
On this date time of the stop, you were also wearing a body cam, correct?
Correct.
And it recorded your interactions this night with Ms. Lazinski.
Correct.
Have you reviewed that footage?
Just the excerpt in question.
You
I
have.
was made aware of the timestamp.
Okay. Okay, great. At some point in time, I think you testified a few moments ago, you were informed by one of your fellow officers that Ms. Lazinski was friends with the local police chief, correct?
Correct.
And the part that I'm thinking that you're saying that you reviewed on your body cam, do you remember your response to that statement?
Cast, I guess you said.
Okay. Do you recall saying, just so you guys know what I saw?
Yes.
And then you went on to tell your fellow officers what you observed, correct?
I wanna make sure that clear what I was telling Goldsmith was a very brief summary synopsis.
I'm just asking if you told your fellow officers what you observed.
Yes,
And in fact, you said, quote, just so you guys know what I saw coming down Gibraltar when she turned from Telegraph. Does that sound accurate?
right?
And when she turned from Telegraph onto Gibraltar, correct?
Is that a yes?
Yes, I'm sorry.
So, we'll remind you. And then you went on to say, I thought she looked like she was over the line. I couldn't really see it.
Yes,
Coming down Gibraltar, correct?
yes,
So, in that statement, you did not, in the statement to your fellow officer, you did not say you saw her driving on Telegraph, correct? That summation that we're talking about that was on the body cam, that you did not indicate to your fellow officers that you saw her on
I didn't, I
Telegraph.
did not tell Corporal Goldsmith the portion of her driving that I did see on Telegraph, no, I did not.
You did not state that she was directly in front of your scout car on Telegraph, correct?
Right.
And you did not tell Officer, is it Goldsmith?
Corporal Goldsmith,
Oh, okay, that you observed the defendant swerving on Telegraph, correct?
did not tell that to Corporal Goldsmith.
You did not tell the corporal that you followed her as she turned on to Gibraltar Road, correct?
That's what I was telling him, but where you're wording it just a little bit, you hear that different.
So your
Get
wording
a
doesn't.
clear answer.
Okay. And in fact, you said, I thought she looked like she was over the line. I couldn't really see it, correct? Is that a yes? So in your written police report, you placed your first observation of the defendant on northbound Telegraph.
Correct.
But your comments to your fellow officer, you placed your first observation on Gibraltar Road as she's turning, correct?
That's what I told.
These are two different locations, you would agree? And your written and recorded statements describe two different sequences of events, you would agree?
Not quite.
Do they describe the exact same events? Yes or no?
The sequence of events I was counting to.
I'm just asking if you're.
I object, Judge. Let him answer the question.
Yeah,
She's
let-
interrupting him before he gets.
Yeah, let him finish the answer. Go ahead and answer, sir.
The sequence I gave Corporal Goldsmith was all the way through the entire sequence of observations that I had made regarding the public.
So when you said, just so you guys know what I saw, it's your statement that you then just told an abbreviated version?
Giving him what would be an incomplete picture, or in your words, an abbreviated sequence. Very.
And then when you told Corporal Goldsmith that I thought it looked like she was over the line, I couldn't really see.
Mhm.
Is that, yes, you remember saying that?
I'm saying,
Is, that also was not stated in your written report, correct?
it's not in the report, no.
In your written report, you say you saw her crossing over the solid double yellow lines an additional 2 times, correct?
Mhm.
Is that a yes?
Yes, I'm sorry, yes.
It's okay.
But yet when you were talking to your officer, your fellow officer, you said you couldn't really see her as she turned.
Can I explain?
Correct.
No.
Well,
Can I have-
your lawyer, wait a minute, prosecutor can ask you a question.
Yes, yes, that's correct, that's what I said.
Okay,
May I?
no, let the
Okay.
prosecutor ask the question if you
Okay.
feel so inclined.
So your decision to stop her that night was based on you saying that you observed traffic violations, correct?
Yes, ma'am.
Specifically swerving and crossing over the yellow line, correct?
And the white lines. The lane markers aren't coming back from the road.
So would you agree that the timing and location of your observations as reported in your written report are important to justify a traffic stop?
What do you mean?
The what you write in the report is the basis of your stop, correct?
Yeah,
And today, your report and the statement that we're talking about with your fellow officers do not match, correct?
I don't.
So you think you told your fellow officer exactly the same thing you had written in your report?
So if you review the body camera, as I did, just for this one exit that we're talking about. Maybe a 30-second block of time, I'm not really sure, but I go on to tell Officer Goldsmith that, yes, I did lose contact of her car as she turned up to Gibraltar, and I was catching up to Gibraltar myself. But you can see on the edge of the frame, my hand is making this motion, meaning as we continue down Gibraltar, I saw her swerving over the lines again. To which Goldsmith then finished my
Did
sentence.
another car get in between you and Mr. Chinsky's car?
Recall that.
In your report, you write directly in front of my scout car. She was, correct?
Mhm.
And
Is
that,
that a yes?
Yes, yes,
and that would be accurate, correct?
yes, that's my recollection.
Under cross-examination, Ms. Aycock established that a formal police report must serve as an accurate and complete record of an officer's real-time observations, which Corporal Hunter agreed. With that foundation in place, the defense then exposed a significant gap between the officer's written narrative and what his body-worn camera actually captured. While Corporal Hunter's report asserted a continuous line of sight behind Ms. Lazinski's vehicle and described distinct lane violations on both Telegraph Road and Gibraltar Road, the bodycam footage showed the officer telling Corporal Goldsmith at the scene that he lost visual contact during the turn and could not clearly determine whether a violation had occurred. Confronted with this recording, Corporal Hunter was compelled to acknowledge the conflict between his written statement and his on-scene verbal admissions. Under Michigan Rule of Evidence 613, a witness may be impeached by a prior inconsistent statement, provided that the witness is given the opportunity to explain or deny the earlier statement. By introducing the bodycam audio, Ms. Aycock effectively converted the reports into contradictory claims. This type of impeachment is significant because it does not merely suggest that an officer misremembered a detail. It directly undermines the reliability of the foundational document the prosecution relies upon to justify the stop in the first place. Under the precedent established in People v. Dillon, Michigan courts have held that a warrantless traffic stop is constitutionally valid only when the officer possesses a reasonable, articulable suspicion that a violation of the vehicle code has occurred. Because the stop was conducted without a warrant, the burden falls on the prosecution to establish that a valid exception to the warrant requirement existed at the moment of the seizure.
Mr. Caven?
Corporal Hunter, did you go through all the FSTs and inform Officer Goldsmith how she did on the FST?
I went to the SFST as trained.
Did you tell Officer Goldsmith the results of the FSTs as you performed?
If I recall correctly, he was there. So,
He was there.
yes,
So was he there for the BBT?
I recall, yes, he was.
He was, okay. So you wanted to explain your answer before about when you started to tell Corporal Goldsmith about the stop.
About the reason for the stop. yes.
Okay, so what did you want to tell the court?
So, as I initially observed her on the telegraph, she being ahead of me, turned on to Gibraltar.
Okay,
There was a period of seconds, some period of time when I lost the visual contact with her. Because I had to then turn on to touch Gibraltar itself.
right,
But once on Gibraltar, and this is what I use my scout class dominant to find later, there was almost a mile of roadway between Telegraph and eventually Mayfair on Gibraltar.
Okay.
For that distance, that's where I would have been behind us.
so when you say that you lost, let's like that. When she made the turn onto Gibraltar Road, you couldn't fully see whether or not she crossed the lines, but you thought she might have. Is that an accurate statement?
I couldn't see, yeah, correct.
Okay, so let's leave that one out of the picture. Did she cross the line before that point?
Yes.
Did she cross the line after that point? Any other questions?
Any other questions?
So your testimony a few moments ago was you lost sight of her vehicle for a few moments as the turn was occurring from Gibraltar, from Telegraph onto Gibraltar, correct?
Yes.
In your written report, would you agree with me that you wrote that Officer Hunter continued to follow the vehicle as it turned and traveled eastbound on Gibraltar Road, crossing over the solid double yellow lines?
Yes.
So your report indicates that as it was turning, you observed her crossing over the lines?
But on my report indicates that I continue to follow her.
And you observed her as she turned, crossing over the lines, correct?
But I believe my report indicates no.
Is your report accurate?
Can I read? Can I read, please? Can I read it just to make sure?
Well, do you need to read that to refresh your recollection?
Because I want to make sure that what I say matches what's in my report. And my report states that I was following her on her ball when I made these observations. Just like I just told Prosecutor Kaylee, when she turned on the Gibraltar ahead of me, I did not see her. Because I couldn't.
Did you state in your report anywhere that I'm not aware of that you lost contact with her, visual contact with
I have
her?
not stated.
But you felt it was important enough to tell Officer Goldsmith that you couldn't see her. You couldn't see whether or not she crossed over the line in your brief narrative to him.
Yes.
And in fact, you said, I thought she looked like she was over the line. I couldn't really see it, correct?
Yes.
So you felt it was an important part of the events that when you summarized, and your testimony is, you gave Officer Goldsmith a summary of the events. You felt that was important enough to say to Officer Goldsmith. Correct.
So she sure was.
But you didn't find it important enough to say you observed her swerving on telegraph, correct?
About telling Officer Goldsmith or in the report?
When you told Officer Goldsmith.
Did tell, that's what I was saying, that's what I was saying about the video camera. If you look back at the body camera footage, you can see as we continue this brief
No, I'm asking
conversation.
you, I'm not asking you about that, I'm asking you, when you told Officer Goldsmith, because your testimony was, you gave him like a Reader's Digest version of what occurred.
If that's, sure,
Like-
I'm not feeling, I'm sorry,
A brief summary,
very brief.
that's your testimony, correct? So, your brief summary included something that was not in your police report,
Yes,
which was, I lost sight of her, I couldn't really see as she turned going down if she crossed the double line.
couldn't see as she turned on the ball.
And that was important for you to tell Officer Goldsmith.
Yes,
You thought it was an important moment in
Thought it
the
was
case,
I thought it was worth mentioning.
but you didn't think it was worth mentioning. Don't strike that. You did not mention to Officer Goldsmith that you observed the defendant driving on Telegraph and she swerved on Telegraph, correct?
I think it was worth mentioning there.
According to your police report, that was one of the basis of your stops. Swerving on Telegraph, correct?
Well, locality and circumstances was best to stop, yes. The swerve on telegraph was my initial, we might call it yellow flag, that at least follow the car. Anybody can swerve over a lane, then. Just go like talking, no,
But you didn't tell Officer Goldsmith about Telegraph, did you?
I think it was,
And in fact, you told Officer Goldsmith that you were coming down Gibraltar Road, correct?
that's,
So you didn't think it was important to tell Officer Goldsmith you were even on Telegraph.
oh,
So after you found out that my client was friends with a local police chief, and I think you responded earlier, you testified and you said like, or oh, or something like that.
what is that?
And then you told Officer Goldsmith, just so you guys know what I saw. And you didn't mention Telegraph, correct?
No, I didn't.
Mr. Kion responded by arguing that the stop satisfied the constitutional threshold for an investigatory detention. Relying on the standard established in Terry v. Ohio, the state contended that Corporal Hunter possessed specific articulable facts, his initial observation of the vehicle swerving on Telegraph Road, that provided a lawful basis for continued surveillance and the eventual stop, evaluated under the totality of the circumstances. Mr. Kion further noted that following the stop, Corporal Hunter administered field sobriety testing in accordance with the implied consent provisions of Michigan compiled Laws 257.625A, including both standardized field sobriety tests and a preliminary breath test. Under Michigan law, implied consent means that any person who operates a motor vehicle on a public road is deemed to have consented to chemical testing if lawfully arrested for an offense related to intoxicated driving. Mr. Cahan argued that these test results provided independent probable cause supporting Ms. Lazinski's arrest. Ms. Aycock, however, moved to suppress the entire evidence gathered after the stop under the constitutional exclusionary rule and the fruit of the poisonous tree doctrine, first articulated by the United States Supreme Court in Wong Sun versus United States. The doctrine provides that evidence obtained as a direct result of an unconstitutional search or seizure is inadmissible, as it is considered tainted by the initial illegality, because the defense argued the stop itself was unlawful. All derivative evidence, including the field sobriety test results and preliminary breath test metrics, would be subject to suppression under the Fourth Amendment.
Any argument?
Briefly, John.
Sure.
You know, I mean, it's a very clear case to me. Corporal Hunter observed this F-350 cross the yellow line. It was directly in front of him. He followed her, like he said, it's a yellow flag. When she made the turn, I think he's just being honest. I couldn't see whether or not she crossed the yellow line on the turn, the double yellow line on the turn, but to me, I don't think it matters. He continued to follow her. She crossed the double yellow line and made several lane infractions 2 more times after that. To me, Judge, it's very simple. He had reasonable articulable suspicion. He had probable cause to pull over and arrest her. He did everything. Field sobriety test, PBT, arrested her. Then there comes this nonsense about now somebody mentioned that she knows the chief of Gibraltar. My client, the Corporal Hunter says, I don't even know, didn't faze me one way or another. To doing my job, she was already arrested at that point, she was already in the squad car. Very simple for me, Judge. There was probable cause to arrest, there was reasonable suspicion, he did everything by the book, the motion should be denied. Thank you.
Briefly on. You know, we have very conflicting statements here. The officer says he couldn't see, he just testified a few moments ago, he couldn't see the double yellow line. And then his report says the defendant crossed over the same double yellow line twice, and he testified that that was in his report. These are 2 different accounts of when he first observed and what observations he made. The officer said he couldn't really see, but his report says he could see, and she crossed over twice, he says, not just once, he says twice, he testified. We all know our Constitution requires that there are specific articulable facts to establish reasonable suspicion for initiating a traffic stop. We don't have that here. This officer's given 2 different accounts of what occurred, where it occurred, and if the observation even occurred. In his narrative, he said he saw crossing over the double yellow line twice. And his body camera and his testimony says, well, he couldn't see. I was a couple car lines behind it. I don't really know. I couldn't see. So both of these accounts cannot be true. Something's not matching up here. These are not minor differences. These differences go specifically to where the officer claims he saw an infraction occur that gave rise to him to stop her vehicle. As a result of that stop, she has now been charged with a crime. You cannot rely on conflicting versions of what occurred and what gave rise to this suspicion to justify a seizure. Timing, location, swerving, seeing something, not seeing something, all very important aspects. And his testimony that he couldn't really see, and his report saying he saw it happen twice, and his testimony that his report is accurate.
Don't you think his testimony was just consistent with that, though? I think what he told me is he couldn't really see from telegraph whether she crossed over the lane marker as she was turning onto Gibraltar from where he was, but then he saw her do it twice over the double yellow lines on Gibraltar between Evergreen and Mayfair.
Never states in his narrative that he lost track of the vehicle, says that he saw her the whole time in his report, saw her cross over twice in his body cam video. He doesn't mention he's behind her on telegraph. In fact, he specifically says coming down Gibraltar when she turned, which places him on Gibraltar Road, not on Telegraph Road. There are many, many inconsistencies on that. And the body camera specifically says, just so you guys know what I saw, coming down Gibraltar when she turned from Telegraph onto Gibraltar. I thought she looked like she was over the line. I couldn't really see it. That's what, and he testified that that was accurate. We can't have 2 two different stories. So that being said, it is defense's position that they have not met their burden for reasonable suspicion. We would ask that the motion be granted and stop be found unlawful, and that any evidence obtained from that stop be suppressed.
Thank you. Anything else?
Yes, Judge, I agree with you 100%. I think he just picked up where he, after the term, his testimony is totally consistent with everything that she just said. All the only point is that he started telling Goldsmith what he observed on Gibraltar Road. No, he didn't say, I observed her while I was driving on Telegraph Road, but that's what drives me crazy about these body cams. If everything isn't 100%, you know, this guy's just trying to tell the truth. I didn't believe her when she made the turn. To me, that's not relevant.
No,
He didn't consider that in the stop.
I don't-
She crossed the yellow line before that and 2 times after that.
During the hearing, Judge McNally attempted to reconcile the officer's timeline by suggesting that Corporal Hunter may have observed 2 independent lane violations further down Gibraltar Road between Evergreen and Mayfair after the initial turn, infractions separate from the one the officer admitted he could not clearly see. Ms. Aycock challenged this reconstruction as a post hoc judicial interpretation unsupported by the evidentiary record, arguing that the court cannot substitute speculative reasoning for the objective digital record captured on the Bodycam. Ms. Aycock grounded this argument in People v. Williams, under which Michigan courts have held that the constitutional validity of a traffic stop must be assessed at the precise moment of the seizure's inception. The state cannot retroactively supply a factual justification for a detention that lacked one when it began. Under the Fourth Amendment and Article 1 of the Michigan Constitution of 1963, law enforcement officers are prohibited from conducting unreasonable searches and seizures. A traffic stop constitutes a seizure within the meaning of these provisions, and it must be supported by articulable facts sufficient to give rise to a reasonable suspicion of criminal or civil infraction activity. Ms. Aycock contended that by proceeding to a warrantless detention without a reliable factual nexus between Ms. Lazinski and a specific observed violation, Corporal Hunter ran afoul of these fundamental constitutional protections.
I don't disagree with you. I'm sorry, Ms. Aycock. I mean, you did a really nice job on the brief and the motion, and I read it twice because it was intriguing, but I do think he was traveling behind her on Telegraph, going northbound. He observed her travel over the lane marker, and then I think he didn't see her, which would be consistent, whether or not she went over the middle lane marker as she was turning onto Gibraltar. But then I think he saw her twice crossing the double yellow lines on Gibraltar between Evergreen and Mayfair. So I'm sorry. I mean, I see your point. I read it twice, but I'm convinced that there was reasonable suspicion. He had every right to stop her, and then that there was probable cause to arrest. I'm going to deny your motion to suppress. Now, I don't know what you guys want to do, but I've either got to resolve this today or we've got to send out notices. Are you guys in a position to resolve this now?
Not right now.
Well, I'm not adjourning the jury. And I can only tell you, I'm not going to be a happy camper if somebody comes in. I got to send out the jury notices.
Well, I think my client's entitled to have a conversation with me based on your ruling today and not go out in the hall and spend 5 minutes. It's part of their life.
Well,
So,
all right, don't be wise about it.
no.
You could have been a little nicer about it. I appreciate the fact that you might be disappointed. Well, that's fine. That's fine. Don't come in that day or I'm not taking a plea to anything less other than charge. That's all I'm telling you about. There's no further pre-trials. I will not take a plea to less than OWI on the date of the jury trial. So if you resolve it before then, I'd appreciate it if you call. If not, just know I will not take a plea to less than OWI charge.
Judge McNally denied the defense's motion to suppress, ruling that under a totality of the circumstances, Corporal Hunter possessed both the reasonable suspicion necessary to initiate the traffic stop and the probable cause necessary to effectuate the arrest. The court held that the officer's observations of the vehicle's erratic movement constituted specific, articulable facts, establishing a sufficient factual foundation for a lawful stop at its inception under the Michigan Vehicle Code. Judge McNally also addressed the prospect of a plea agreement, stating that he would not accept any resolution in which Ms. Lazinski pleaded to a lesser offense than operating while intoxicated. This is consistent with well-established principles of criminal procedure. Under Michigan court rule, a judge is not bound to accept a plea agreement negotiated between the prosecution and defense and retains the independent authority to reject any agreement that does not serve the interests of justice. As I'm writing this video, Ms. Lazinski accepted a plea agreement of operating while impaired, and the state dismissed the original charge. Her sentence is scheduled for May 28, 2026. This case illustrates the critical importance of Fourth Amendment protections in the context of traffic stops and the role that contemporaneous evidence plays in evaluating the credibility of law enforcement accounts. The defense mounted a focused, document-driven challenge, using the officer's own recorded words to expose the gap between his written report, Bodycam, and his real-time admissions. While Judge McNally ultimately found the stop constitutionally valid, the hearing underscored a principle that runs throughout suppression practice, that the state's evidence must withstand rigorous scrutiny before a prosecution can proceed. Even when an officer's underlying instincts prove correct, the defense retains the right to hold the government to its constitutional burden at every stage of the proceedings. Comment below if there is a case that you would like us to cover. Thank you for watching, and don't forget to subscribe to see more case analysis.